bring contempt charges to the U.S. Attorney under a 1857 criminal statute. There is not a lot of wriggle room in the language of the statute. The House and the Senate may submit contempt charges to the U.S. Attorney, whose duty it shall be to bring the matter before the grand jury for its action. Despite that unequivocal statutory requirement, when Congress referred contempt charges, criminal contempt charges against Josh Bolten and Harriet Miers, Attorney General Mukasey refused to allow the U.S. Attorney to present the charges to the grand jury. He argued that criminal prosecution is exclusively an executive branch power, and Congress cannot compel the executive branch to bring a criminal prosecution regardless of what the statute said. In a 1987 decision, the Supreme Court held that a trial court could appoint a private prosecutor to bring a contempt of court proceeding where the appropriate prosecuting authority denied the court's request to prosecute. The Supreme Court held that a trial court's power to appoint a private prosecutor was based on the trial court's inherent power of self-protection. If the judiciary were completely dependent on the executive branch to redress direct affronts to its authority, the Supreme Court said, it would be powerless to protect itself if that branch declined prosecution. Congress cannot depend entirely on the executive branch to redress direct affronts to Congress's authority any more than the courts can, especially when the affront is by the executive branch itself. Second, the U.S. Justice Department's Office of Legal Counsel is little known to the general public, but it exercises remarkable power. The Bush administration has fully realized the potential for the abuse of the OLC's power. The Bush administration has, instead of seeking disinterested legal opinions from the OLC, the Bush administration has demanded and gotten exactly the opinions from the OLC that it wanted. And the Bush administration has received those opinions and acted on those opinions in secret, placing the opinions beyond any challenge. Even when the OLC obligingly advised the Bush administration that the Bush administration could just ignore the requirements of statute. The Bush administration asserts no exigent circumstances, no practical necessity for that breathtaking claim of power by the OLC, that they can exercise in secret that legal power. It is simply a calculated expansion of presidential power at the expense of Congress and the courts. I'm now working with Senator Feingold and with others on legislation to require the OLC to report opinions to Congress, especially where the OLC decides that the executive branch can just ignore statutory requirements. James Madison wrote, "The founders of our republic provided against the usurpation of power by providing each branch of government the necessary constitutional means and personal motives to resist encroachment of the others." Madison wrote that the constant aim is to divide and arrange the several branches in such a manner as that each may be a check on the other, that the private interest of every individual may be a sentinel of public rights. The Bush administration's claim that the president alone decides, in his own unreviewable discretion, what to tell Congress and the American people is an encroachment that we must resist. And by jealously asserting our rights under the Constitution, we defend the public rights. Thank you.
Everything up to the time of the Cold War that was done by presidents in time of crisis was known. And in case of Lincoln, what he did, he asked the Congress, he said to the Congress, you know, you may disapprove of what I've done. If you do, please criticize me, but I'd like you to ratify what I've done. And they did ratify what he did. Then came along the Cold War, and we began to have excessive secrecy. And the great lesson that the Church Committee learned and that we're learning again today is if you have secrecy and you have a lack of oversight, you are bound to have two things. One, abuse, but even more importantly, you're likely to have mistakes. Because the great lesson of James Madison in the 51st Federalist, where he said men, we'd now say men and women, are not angels, the great lesson was